I want to ask you about your use of the word clandestine. Why can you expand a little bit on why you think ASIC use clandestine tactics in your language, and what type of clandestine tactics did they engage in?
Well, I mean, at the simplest form, we were never actually alerted of any wrongdoing, any trade that was a problem. I was actually informed by my broker, Macquarie, that ASIC had called them and to cut me off immediately from trading, but no trade had ever been identified. And I later learned that shortly after the call that was made to Macquarie, which, again, this is hearsay, but what was told to me by the people of Macquarie, that was effectively they were blackmailed to shut us off, that they had made calls to 7 or 8 of the largest global brokers in the world, effectively calling me a criminal and telling me for them not to do business with me. And then after that, sending a circular around to all of the brokers in Australia, alerting them that if I contacted them, again, not to do business with me, and to not tell me that this circular had been sent around. I mean, any other broker, any other regulator in the world would send you an inquiry with basic questions on the trading and look for evidence to establish a case of wrongdoing. They wouldn't just attempt to block you out with no due process.
It does seem very unusual that a securities regulator would be making 7 or 8 phone calls, if particularly in the absence of any formal statement being made. Was there any formal statement made by ASIC about any concern they might have about your organisation's conduct at that time?
No, not at all. They just published issue 53 of their market supervisory guidance, which basically identified myself as a bad actor, and I got effectively a retraction printed in 54, which at the time my counsel told me was a great win against somebody like ASIC, but I didn't know about the phone calls or anything until later on.
Okay, and have you verified with others that those phone calls occurred?
Yes, it was in the testimony at the trial. Look, we deal with regulators and capital markets all over the world. Financial markets want certainty and market integrity. This means market regulation that is fact-based, that allows due process, that honors natural justice, and that is accountable for inappropriate conduct by the regulators themselves. Our case clearly demonstrated that all 4 of those elements were solely lacking in Australia. The Court of Appeal made a point on commenting on the complete lack of evidence when any decent oversight system would have been able to retroactively identify in minutes or hours the harm that we had caused. They had several years to find something and came up completely empty. They also gave us 0 notice of any specific concerns and thus no chance to respond to any allegations. Instead, they pursued clandestine tactics of insinuation and intimidation to accomplish their personal goals. Direct evidence of internal ASIC correspondence to this effect was introduced at the trial. ASIC's chief general counsel had previously blatantly denied their smear campaign they engaged in and was later unequivocally established at the trial. These are the tactics of a bully, not a proper market regulator. In our case, ASIC decided they could operate as a witness, prosecutor, judge, jury, and executioner. This cowboy conduct only flourishes when they have no effective accountability or any type of oversight as an all-powerful regulator. That is the core of the problem and have rightly been identified as the worthy analysis of this committee. We brought our lawsuit against them only because ASIC chose to broaden their smear campaign unsuccessfully internationally. It was a very expensive and timely process for us to attain justice. However, you should remember that Australians whose livelihoods depend on participating in your financial markets could likely not afford the risk of attacking these unaccountable, all-powerful regulators directly. The very real threat of retribution, direct or indirect, is just too great, and that in turn perpetuates your problem. You should also know that in the international markets, this unfavorable reputation of ASIC is well known and has likely impeded the participation that would truly elevate your market's efficiencies and integrity. These regulatory shortcomings can foster self-perpetuating adverse issues. Reduced participation means reduced investment and reduced liquidity. Reduced liquidity hurts all Australian investors, retail and institutional alike. When we were banished, the institutional community immediately noticed, as I said before, that 400 Australian stocks effectively went dark. The real cost flowing from ASIC's inappropriate conduct has never been properly quantified. What's interesting about this case, which was that we actually, through Freedom of Information requests, got internal emails of ASIC, where they were kind of celebrating and giving each other basically virtual high fives about basically blocking me out of the market with no due process. Like, they knew what they were doing. And no other regulator that I've ever dealt with, look, we deal with, again, everybody worldwide. No other regulator has ever acted where there's no due process. Like, you get a question, you respond to the question, then they further ask any other trade detail or any information. And if they believe, I've had situations where we don't agree with the regulators on their views, but you still have a process and a formal process where you go through it. I've never been in a situation where I've been effectively called a criminal to brokers around the world. And then when I ask the regulator if they did it, they lie to me and say they've never done it. I mean, that just doesn't work out like that. I mean, lawyers have a duty to be at some level honest. And they had no intention of ever investigating me. Their assumption was that I would never come back. In fact, I had a conversation with one of the lead people at ASIC, and they effectively threatened me, saying they didn't think I could afford to sue ASIC. Right? And I don't think they understood the scale of my business, and I don't think they understand the damage they were doing to it, to the point that I could. This cost me a lot of money, and I would have never done this if they had just kept it effectively to the island of Australia. But when you start making phone calls and trying to get people within large institutions to speak to their colleagues in New York and London, it wasn't somebody in Australia that called me to tell me these calls were being made. Everybody's scared of ASIC in Australia. Nobody's going to speak out. The calls came to me from Hong Kong, London, New York. That's how I found out. So it would never work like this. Like, there should be issue 53 in itself should have never been published without asking me a question.